Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, Early Identification and Resolution of High Exposure Claims. This event is brought to you by National Arbitration and Mediation and sponsored by Law.com. Before we begin, let's go over some basic housekeeping items about the webcast console. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console. You don't have to open a new browser to do so. Simply scroll along the bottom of the screen and click on the social networking widget of your choice. In fact, we encourage you to do so. If you have a question for our speaker, please enter it in the Q&A widget on your console. We will get to your question during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So if you'd like to change the look and feel of your console, go right ahead. This event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. Participants who wish to receive credits for other states must check directly with their CLE board. During this presentation, the CLE code will be announced. After the presentation, all participants will be prompted to complete an evaluation form. There will be an area on the evaluation form that prompts attorneys for the code. Only New Jersey and New York attorneys should enter the code. New Jersey and New York attorneys should also be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. CLE credit is available for attorneys in the approved jurisdictions on the live webcast date, March 21st, 2019. 1 week from today, on March 28th, all participants will receive an email with instructions on downloading state-specific CLE certificates. And now, for today's topic and the reason you are all here. High exposure claims have the potential to be costly. Learning to assess the potential for a claim to turn into a major claim and working to find resolution early on will save time and money on both defense and indemnity in the long run. Here to address how to perform a detailed, objective analysis of complex information to achieve the best strategies and results for claim resolution is Bob Worden, hearing officer at NAM. Bob has over 35 years of experience litigating in the New York metro area and representing both plaintiffs and defendants. So without further ado, I will go ahead and turn the floor over to Bob to kick off today's discussion. Bob?
Thanks, Kelly. Good afternoon, everybody. Bob Worden, and I look forward to giving you this presentation. It's my favorite CLE to give. We go to a picture of me after many years in the pits and being beaten up on both sides. That's what it's done to me. Let's go to the content. The whole point of this CLE is to try and get cases closed sooner than they are typically, and it's something I've been trying to do ever since I started doing defense work. First half of my career was primarily doing plaintiff's work and gradually worked into defense work, which is the majority of my work now, although I'm spending a lot of time at NAM doing mediations. Anyway, the key thing to start with is that you have to be proactive to get your case resolved. We didn't used to have that word proactive, but it just means to give your best energy to getting the job done. And when I started out as a plaintiff, I found that the first job I got was sort of a general practice firm, and they didn't know how to manage me. And so I did my best, but after 6 months, they said, "We got to let you go." I was surprised and shocked. I'd never been let go before, and I vowed that it wouldn't happen again. And then I got a job working for a guy who did only plaintiff's work, and I knew that he wasn't really a manager either, but I took the opportunity to work hard, and it paid off, I think. So what I would say is you've got to be looking at all your cases early on and doing what you need to do. And as a plaintiff, you don't get paid until the end, so you've got to work them as well as you can to move them forward. And when I started doing defense work, I was actually shocked to learn that the insurance companies actually wanted to pay money, that they wanted to close cases. And so having already that mindset of getting things done quickly and efficiently, I got deeply involved. Now, this first slide, I want to talk about a case I had where a lady got a bad electric shock at a health maintenance organization, and I got it to defend, And the problem they had was that they sent over an investigator to talk to their insured, who was my client, and the investigator got no results. It was a big bureaucratic place, and nobody would talk to him, and he'd wait in the lobby 2 or 3 times. So I finally talked him into letting me go over with a suit on and trying to be nice. And I found out that after going through about 3 or 4 people, I found out what really happened. And what had happened was this lady had been unplugging a X-ray view box to view X-rays at this HMO. And it turned out it should have been a hardwired box, but when they bought it, nobody ever went around getting a switch attached to it like a wall switch, but instead every day someone would come in and plug it, and every night they would unplug it. So she unplugged it and got a bad shock, and she got a condition called RSD, which I know many of you have run into, a reflex sympathetic dystrophy, now known as complex regional pain syndrome. And it was fairly early on in the case, probably maybe 9 months after the accident. And I was there, and I could do my investigation and get the facts. And that's the point of telling you this story, is if you get the facts early and pin things down, you can move things early. So having gotten the real information that this was going to be a liability case, I also asked to see the supervisor of the person who got injured, because that's a big part of every case too. Who's suing, and will a jury like them, and are they for real? And it turned out the supervisor told me that the lady was the best employee she'd ever had. She was trying to come in, but she was having real problems with her hand, but she was just a terrific person. So I went back to the insurance company, and we discussed it. And the firm that had it was a good firm, very well-known, big firm. And I told them we'd like to settle the case, and we settled the case about 2 months after I went into it, went into the HMO. And that was a good result for everybody. It could have gotten worse, and the case could have been worth more money, and the insurance company would pay more. The plaintiff's attorney didn't have to work too hard and got a very nice attorney's fee. And, of course, the insurance company saved the defense costs, which are always very closely measured by insurance companies. So that's the kind of result I think everybody wants. And it's a bird-in-hand philosophy that I have, and I think it's a philosophy that wins for most people, plaintiff or defendants. Let's go to the next slide. Risk transfer. Plaintiffs don't hear about this too much, but it really means the fight amongst insurers, usually with indemnity and additional insured coverage and things like that, to try and figure out who is going to pay the settlement. And this is something that can slow down your cases dramatically. And we always suggest trying to get those risk transfer issues resolved as quickly as possible. If you don't, a lot of times you can't even settle the case because nobody knows who's going to pay ultimately. It's a lot harder. And this reminds me of this story I put at the bottom of the slide, the exploding gang box. We had a case up in a big shopping center that we were defending, and somebody put an acetylene torch into a big toolbox called a gang box. And at this shopping center, there were about 12 different stores that were being built all at the same time, and contractors all over the place. And somebody had opened up this box, and it exploded, and he got badly burned and injured. And it took us, I would say, almost 3 years to get the risk transfer done, because there were so many different insurers and contracts and the rest of it, and it went up on appeal. And 2 weeks before the case was to go to trial, the appeal was resolved, and everybody knew who was going to have to pay. So the point of this is to try and get these decisions made early. And if you're a plaintiff and you got the case and you're pushing it forward and you're not getting answers, this could be one of the reasons why. And you might want to mention it to the defense attorneys and ask them what they're doing, and try and get involved in it to the extent of motivating people to resolve it, and to let them know that you're not going to wait, that you're going to push your case to trial until you have an answer. Okay, let's go to the next slide. The first line on that slide is, it doesn't have to be a war, and it really doesn't. I found that being nice and congenial and talking to the other side in a friendly way is the best way to get things done. People will receive you better. They'll be more likely to listen to your ideas. And then also learn what they need. and we'll talk about that more on the other side. And certainly, if you're on the defense side for an insurance carrier, or working for an insurance carrier or defense counsel, understand that the plaintiff's attorneys don't get paid by the hour. Be considerate of how hard their job is. It really is very difficult. Their cash flow is different. Everything is different. They just don't get a salary at the end of every week. So understand that sometimes they can get angry if they feel that they're not being treated with respect or if their time is being wasted. Next slide, the plaintiff attorney mindset. That's what we're talking about. They want to be efficient, only get paid at the end of the case, and they get paid the same attorney's fee whether they work 50 hours or 500. And it gets them more clients if they move their cases more quickly from referring attorneys or word of mouth. So understand that. And then when we talk about the psychology of the plaintiffs themselves, that's the next slide. Most plaintiffs, when they come into your office, and I've interviewed hundreds and hundreds of them over the years, they want to know, do they have a case and when will they get some money? And if they are seriously injured, they tend to, over time, get depressed, angry, and harder to deal with. And this can create problems for you when you're a plaintiff's attorney because they may not want to settle the case for what's a reasonable number, particularly if the liability in the case is uncertain. It can be very hard to explain to them that they could go home with nothing if they're not careful. And so by settling the cases earlier on, you're likely to get a happier client. And, of course, you do less work, too. Also, I put on the end of this slide the idea about cash funding. We're seeing a lot of that now, and people are getting money in advance in return for very high fees when the case comes in, and that's getting in the way of some settlements. So if you can move the case sooner, there's less of that to deal with. And the next slide is the claims perspective. And I can't tell you how many cases I've got over the years as a defendant where the company that's being sued, the defendant, they say, oh, there's nothing to it, and you have nothing to worry about, or somebody else did it, and the story changes. And that's something that sometimes hamstrings the claim side of the equation. So you want to keep your mind open on all sides if you're on the defense as to, let's get the facts, let's find out what's really going on. And we haven't heard the plaintiff's story yet, so it's all too easy to just say, oh, this is a nothing case. And I think this approach is the best, which is every claim is potentially high exposure until proven otherwise. If you're on the defense side, please put all insurance carriers on notice as soon as possible. Sometimes the defendants don't want to do that. They don't want their premiums to go up, but it can create problems later, particularly if it ends up being a big case. On to the next slide. Claims person's mindset. They've got a lot of cases. Every time they settle a case, they get two more. They're busy. They know the cases. They're taking a lot of time. And if it's a smaller case, it's a real trap to say, I don't have time to look at this case now. I'll get to it when I get to it. Because by the time they may look at it closely, maybe it's turned into a much bigger case. So this is trying to encourage the claims people to really be on top of every file, because you can get the best result by settling it early. Even if it's a small case, even if it's not that important, you get rid of it, it's going to help your percentages, and you're going to get rewarded for doing it. And again, it shows respect to the plaintiff's attorneys. They know they've got a small case at that point. Why not move it if you can move it? Because those are the cases that drive all the plaintiffs crazy. Everybody wants the big case where they know they're going to get a lot of money, but the vast majority of plaintiffs' cases are a lot of hard work and uncertainty. There's only so much time and energy that they have. So if it warrants it, try to move those cases. Now, the insurance carrier psychology, this is not just the adjuster, but the carrier as an entity, they really don't like uncertainty. They don't like surprises. They have to reserve and set money aside for paying claims, and they want that to be accurate. Obviously, they don't want to pay their defense attorneys any more than they have to. At the same time, they're not going to pay based on speculation. they have to have something documented to look at to justify paying, because they audit within the insurance companies, and people don't get promoted for paying too much money. So that's what their mindset is. Understand what they need. Try to give them what they need. And everybody is measured today. You see metrics all over the place. We get measured as defense counsel, how long our cases age, how many we close, what our average spend per case is, that sort of thing. So the old defense counsel mentality of trying to keep the file open, to bill more on it, nobody's going to have a successful long-term strategy with that. You really want to focus on doing the best possible job you can, and so then your average spend per case is more reasonable, and you get more work. And of course, the metrics are even worse for the claims handlers, who get measured every time they touch the keyboard or answer a phone call or whatever. So understand the pressure they're under if you're on the other side. The next slide, communications between the two. Again, please try to keep it cordial. The best attitude for a claims person, I think, is to say every case has a value. I never want somebody to say this is no pay. The plaintiff took it. He must have taken it for a reason. It must have some value. Show them respect and understand that buying a release is a good idea. You don't want to pay too much, but it ends the case. And sometimes these little cases turn into big cases. Get rid of them. And too often I see from the plaintiff's attorneys that they try to not exchange information that ultimately is going to have to be exchanged anyway. Usually don't see it with the big, well-known firms, successful firms. They give you what they have, and they don't fight unnecessary fights, and their files tend to be smaller than you would think. But there are some attorneys who think that fighting is the way to get the insurance company to pay more money, and it really isn't. Nobody's paying the attention to how much you fight. What they're paying attention to is the nature of the liability and the extent of the injuries, and what do you have on those things. And also, they don't want to make decisions until they have all the information. So if you want to settle your case and you don't give them the information that's at least required, you're not doing yourself a favor in terms of getting the case resolved. This is my think like a juror slide. Plaintiff's attorneys think one way, claims people think another. Certainly the people who are being sued are also thinking with a completely different emotion than what a juror thinks. The juror doesn't really care. The juror comes in and listens and is going to make their decision. But one of the problems is that a lot of times the claims people don't know what facts are going to come into evidence, or the plaintiff's attorneys assume certain facts are going to come into evidence which won't. Either way, it's not a good thing. Let's go to the next slide. Excuse me. Now, chains of counsel. If you're a plaintiff's attorney, what's to stop your client from going to somebody else if you're not working hard on his case or her case? This happens. It happens more and more this year than years ago. And a lot of competition out there. The other thing is many attorneys taking cases but don't want to try them themselves, but they have to hire trial counsel if they can't settle the case. So understand, if you've got a case, you ought to be trying to settle it rather than have to split the fee with somebody else. And the same is true with the insurance carrier. If they settle it early, before another trial attorney is involved, it's going to save them on defense costs. Many of these trial attorneys get paid more if they actually start trying the case. So you see it go to trial and jury selection and maybe through opening statements, and then maybe the case settles. This is costing the insurance company more money. So please think about this, regardless of which side of the equation that you're on. Next slide. This is my favorite concept. Is I try to sell this all the time to insurance companies, is you got the liability against you. Let's say the case is, a hit in the rear, or the Budweiser truck goes up on the sidewalk or something, a case where there's really no defense on liability. Why aren't you settling it? There should be discussions early on. It should be very proactive to get rid of that case. And I've seen many plaintiffs' attorneys, and I've been one of them, very frustrated when you have a good liability case, and for some reason nobody's making any decisions. I think I should also talk at this time about personal lines insurance carriers and commercial insurance carriers. Personal lines insurance carriers insure homeowners and auto, and they insure large numbers of people. And usually the policies are smaller, the insurance policies. So they are really paying attention to the rule of big numbers. When you have big numbers involved, and a lot of them, they can be pretty tight-fisted. So you see them being usually harder to settle with than the commercial insurance carriers who have fewer insureds, but who have larger insurance policies. So sometimes as a plaintiff, you got to recognize that you have a good liability case, you want to settle it, but it's just the particular insurance carrier you're dealing with. You just have to wait. And it's a good idea to talk to your colleagues and look online or whatever and figure out if that's one of those insurance carriers that's just hard to settle with. And that's the way they run their business. That's their choice. Of course, they have the downside of waiting until the end, and sometimes that downside is not good. But more often than not, their policies are smaller, so they're not concerned about that. Okay. The next slide. We talked about this already, but here's some specific examples. First of all, the law may change against the other side. I had a case where a lady fell down a bus. I had it as the plaintiff. Fell down on a bus. They're on their way to gamble in Atlantic City or whatever. And the bus driver moved when he shouldn't have or something else. But she had a significant injury, and I was fortunate that I had an insurance carrier on the other side that I could talk to. And we settled the case for a good number. Again, I think we just ran the plaintiff's deposition and settled it. And then 3 months later, I'm reading the advance sheets as they come down with the new cases, and my exact case is there in the advance sheets, dismissed in New York State where I practice. And I thought, wow, that was really found money. Thank God I settled that case. So that can happen, and it can go either way. It can go against the insurance carrier as well. With regard to infant scar cases, that's one I wanted to share with you. I've had several where they could have been settled early for more money, but for whatever reason, the plaintiff's attorneys think they've got a great case, and then 2 or 3 years later, when it shows up in court, they bring the infant, who's now 2 or 3 years older, and guess what? You can hardly see the scars. So I had one case where we had $150,000 on the table pre-suit, and then I ended up litigating it for 3 years, defending it, and it settled for $140,000 at trial. That's nuts. But we couldn't get the plaintiff's attorney in that case to see what was happening. Now, I had another plaintiff's case myself, great slip and fall case. It was a defect, and there was no doubt about it. And the lady was in her mid-70s, but I was real busy at that time, or I would have pushed it faster. And I'm sorry that I didn't, because by the time we got around to preparing her for her deposition, I have the word EBT. It's examination before trial in New York, depositions in the rest of the country. Anyway, when I went to prepare her for her deposition, she was all over the place, and basically she had entered senility. She was decompensating, and she was getting confused and couldn't keep track, and she was a different person than I had seen 6 months before. And I was lucky in the case in that she did testify at her deposition, and the attorney on the other side was an old pro, was just looking at me and smiling and winking like he knew I had my hands full, but at least I was able to get some kind of settlement out of the case for the lady, probably because her injury was serious. But without her testimony, we couldn't make out a prima facie case. And if I could have settled that one earlier, believe me, I would have. So you have to think about that with your plaintiffs. Are they going to be there? Are they going to leave town? Are they going to disappear? Think about that before turning down opportunity for settlement negotiations. Then also, with regard to bankruptcy of a party, that stops things from moving for 6 months or a year. Let's say death of a defendant, sometimes the plaintiffs die. All of these things can change the whole equation of a case. So why, if you can, why don't you try and take the bird in hand and get that case settled? Now, the biggest example I can remember of this was I was on the defense end, And there was a nice lady who worked at a big hospital in New York City who was late for work and was trying to run around the back of a big garbage truck dumpster type outfit. And it was a crazy scene because everybody was rushing to work in the busy parking lot of this back parking lot of this hospital. And she tried to sneak behind this truck. I think that's what really happened. And she got knocked over by the edge of the truck, and then the truck ran over both of her legs. And then, of course, the bystanders start screaming at the driver, so he does the obvious thing. He reverses direction and runs over her legs again. So we knew it was going to be a bad case from the medicals. She came into the deposition, and her legs were really a combination of pink and red. And she was a very slight person, and she looked like a very fragile. She had crutches under each arm. This was like a year after the accident. And I was worried that she was going to lose her legs because of vascular insufficiency. And so I wrote to the insurance carrier and I said, you really got to settle this case because this could turn into a huge case if she ends up losing one or two legs. And we got no defense. You know, our driver was backing up, but they should have had somebody as a spotter in this area at that time with all these people. So anyway, we settled the case. And then plaintiff's attorney got a lot of money and was happy with it. And then about 6 months later, I heard from the claims adjuster on the file, maybe it was a year, that the lady had died of cancer, entirely unrelated. Somehow she saw a news story or something, and the adjuster who called me up and said, and I was kind of concerned about that because I had been pushing for this early settlement thing, and gee, you know, in case if we'd known that was going to happen, you wouldn't have had to, you know, pay a tenth of that or maybe a fifth of that if she wasn't around with all the future damages and all that. And was I going to get criticized by the insurance carrier? But then I spoke with a guy who was very knowledgeable about it, and he said, no, we call him as we see him at the time. You made absolutely the right decision. You had no way to know, and we're happy that the case settles, cases like that settle, and that's what you should do. So these are the kinds of things I'm talking about in terms of real-life examples that I've lived through. Next slip is, let me stop for a second. We've got to put your CLE codes in. Kelly, are you on? Do you want to do that?
Yes, great. Thank you, Bob. So everyone, the CLE code for this event is Claim 21. That's CLAIM 21. Again, the code is Claim 21. Thanks, Bob. I'll put it back to you.
Thank you, Kelly. Okay, folks, so let's go on to this next slide, the deposition. I feel that I really don't know the case from the defense point of view until I see the client, the plaintiff, I should say, the plaintiff, and talk to them, take their testimony, and I have a much better idea of how the case is going to go. You plaintiff's attorneys have a lot better opportunities because you are meeting them in the beginning and have a chance to decide whether or not to even get involved in the case. So that's a decision for you. But I think that a lot of cases can be settled after the plaintiff's deposition, even before the defense deposition, if it's a case that has liability issues in favor of the plaintiff. So my recommendation a lot of times is to hold the independent medical examinations immediately after depositions, and let's talk about settlement. And I recommend that early on in the cases where I'm defending, that the plaintiff's attorneys anticipate that that's a possibility and get their proof ready at that point, because why not talk about it at that time? Why wait for it to come to trial? Now, I know that different venues move faster and slower. New York is one of the slowest, and the cases can take 5, 6, 7 years. It's not unusual in New York to get resolved. But even in your jurisdictions that move more quickly, why not? Try and plan it around getting the plaintiff's deposition if you've got reasonably good proof that it's a liability case. And also I would say that a lot of times cases get held up because there are non-parties that nobody knows what they're going to say. So why not either send an investigator out to get a statement so at least you know if the statement's really good for you, maybe you exchange it with the other side, or if you can't get a statement, notice the deposition and get that, key witness out of the way. So many times there's an eyewitness in cases who nobody knows for sure what they're going to say until they say it. So I strongly recommend getting the non-parties out of the way sooner rather than later. And then also, if you've got a non-party who you think is going to say something that you like, you might want to preserve their testimony. They may not be around. And if your case depends on a particular witness, most states have a provision that allow you to preserve testimony, so forth. So think about doing that, another way to get your case resolved more quickly. In fact, I just reminded, it's not in my outline, but I had a big wrongful death case as a plaintiff. It happened up in Vermont, and the key witness was from Chicago. And this is when we were just getting into the tech era, probably pretty close to 20 years ago. And we were doing depositions by video, where everybody would go to the video provider. And we took this lady's deposition. I think she was in Chicago, but she had been on a vacation in Vermont. And she was absolutely terrific for my case, absolutely terrific. Just a wonderful witness, and hurt the defendant a lot. And the nice thing was, because it was videotaped, those days they used to video them as well, because why not? That both the defense counsel and the insurance carrier could see just how good she was. And we settled that case pretrial for a lot of money because there wasn't anything they could do. That witness was locked in. So lock in the good proof on your side. The next slide is something that I emphasize with insurance carriers. It's like, don't ignore the small cases. It looks like it's a small case, but you don't know how it's going to go. And the two factors I think are most important to look at are, is the plaintiff getting a lot of treatment, and is the plaintiff returned to work and continued to work? Sometimes they'll go back to work for a couple of weeks and then stop working again. But if they never go back to work, you got a good idea that they're not going to go away for a small amount of money. And you got to figure out, how am I going to deal with this? Are you just going to let it sit for a couple of years and wait for the trial to come up? It's not the right way to go. Probably only going to get worse. It's not going to get better. And if you're the plaintiff's attorney, I guess you could hang on to the case hoping it gets better, but now you got to work on it. If you do that with all of your small cases, you're going to soon run out of energy and time and money. I think most plaintiff's attorneys would like to work on the few really good big cases they have, and if they can move their smaller cases quickly and get a good result for the clients, they don't have to hire as much staff. It's more profitable. Everybody's happier. So my recommendation is for everybody always to try to settle the cases as early as they can. Next slide. I want to get into premorbidity, which means a pre-existing condition, disease that makes people more susceptible to have the effects of the accident go worse for them than somebody who doesn't have that condition. Take that into account. If somebody's got a systemic disease like diabetes, lupus, I remember had a case with that once, multiple sclerosis, that, look at it carefully. And know that most of the aggravation jury charges, they hold the defendant responsible even if the plaintiff is fragile or has the underlying condition. And understand that when you're valuing the case. Here, a slide on diabetes. It can affect almost every part of the body, failing to heal, people losing body parts, people going blind. These are all things that make those plaintiffs more susceptible to injury, and the injuries may have worse effects on them. So, you got a case early on. If you're an insurance carrier, take that into account. And if you're the plaintiff's attorney, take that into account in negotiation and see if you can't get some kind of early resolution. Multiple sclerosis, a lot of times there's a big issue with that one. The claim is, well, they fell, if they trip and fall case, they fell because of their disease, not because of the defect. That's a big fight. Parkinson's disease, you can get the same sort of problem because the people don't move well, they move stiffly. But on the other hand, they can be very sympathetic people because you look at them and you just feel bad for them, and jurors are going to feel bad for them too. We had a case recently, and I hadn't planned on talking about it, where I put even a small loss in ability to this person. I was on the defense side, and a guy had unfortunately had a diving accident and became totally, actually they called him tetraplegic, which is a little bit different than quadriplegic. but he had very little use of his arms and head and neck, and he'd had surgery. And they have him in taking a shower, and the claim, when he falls out of this shower kind of transport chair, the claim was that they should have had two people moving him rather than one person. And that's why he slipped out of his chair. And he didn't actually fall and hit the ground, but unfortunately the one attendant who was with him at the time grabbed him by the head and neck. And he had had surgery on that neck, 6 months before. And he ended up having to have a second surgery. That left him in pretty much the same condition, but he had some changes, some losses. And his mother testified, well, he was really working at rehab and he was really trying to get better, but after the second accident happened, he just kind of gave up, and now he just sits there. And so these are cases that you want to, they require special evaluation. You want to be careful and do a lot of research and make sure you know what you're talking about. Had another case, the same slide, with Parkinson's disease, where the guy had pretty severe Parkinson's disease, and he had a couple of falls that two separate defendants were liable for. One was, or going to be held liable probably. One was the sidewalk where he fell, and the other was a nursing home where he wasn't restrained adequately, I guess, or watched adequately, and he fell again. But after he fell, he became really decompensated and just sitting in bed staring, not really able to communicate. And I remember when we were trying that case, it was a big problem because you could see the jury, once they saw the video of this fellow, after it all, you could just see their minds were closed. It was very hard to make any arguments on the defense that they were going to be receptive to. And, so take that into account if you're dealing with that kind of a plaintiff, both plaintiff in valuing your case and the insurance carrier in defending. Understand that these are high exposure cases and there's risk there. Next slide, spinal injuries. How many times do we see spinal injuries go on to have multiple surgeries? So if you got a liability case, why aren't you settling it? And if you got a liability case with one surgery, why aren't you settling it? If you got a liability case with two surgeries, why aren't you settling it? How long are you going to wait? That's just something to think about. Next slide, it's the reflex sympathetic dystrophy slide. Big thing here is a minor event, complaints of burning pain, and the people who really have it, I don't know, you can kind of look and tell. It's like an eyesight thing. Sometimes they have physical symptoms, but a lot of it has to do with their credibility. Can they sell it or not to a jury? And hard to value. Some of them really are losers and some are winners, and it's very hard to know for sure what's going to happen in these cases. So one of the defenses that people try to use is they'll get a doctor who examines who says, no, it's really all in their head. It's not anything that's happening with their body. But sometimes these people do have changes. Their hands get blue and cold, or their feet get red, or whatever part of the body it is. And the doctors will say that's somatization, which means the body is producing signs and symptoms, but it's really being generated by something psychological or in their brain. But my feeling on those cases is that's not much of a defense. If the jury doesn't think they're faking, they're going to want to compensate them because the person's not really in control of what happened. And so you can always argue that it's an aggravation of an underlying psychological condition, if not a physical condition. So those are some of the tougher cases to evaluate. Traumatic brain injury, I think the big thing in those cases is you need a real substantial impact to the head injury. I mean, other people, plaintiffs' attorneys, may be out there saying, no, you don't, but there's a lot of fights about it. I just think it's harder to defend these cases if you don't have it. And also, what's the condition of the plaintiff immediately after the accident? Were their bells rung or were they fine? What does the initial hospitalization say about these people? That's crucial in these cases. Then you have the junk science. What used to be junk science, and now it's hard to tell what is and what isn't. There's big fights about what's real science now. The quantitative EEG, the functional MRI, the PET scans. There's more and more research being done on these every day. And if you got one of these cases as a plaintiff, you obviously want to get the best expert you got and get a good report. And if you got one on the defense side, it's the same thing because the defense is going to say it's junk science if they've got a top expert who's credible, who's going to say that, and is it going to be a fight or not? These are hard claims to resolve. But why wait until the end to resolve them? Why not resolve them sooner? Now, let's go to the next slide. Experts. I put catch-22 because a lot of plaintiffs' attorneys don't want to spend money on experts until they have to. But without the expert, how do you convince the defense that you're going to be able to prove your case? One of the things I've seen happen on both sides, and the experienced trial attorneys on both sides like to have one expert do the work of two. And if you can do that, that's a good thing. So, for example, on the defense side, if you can have your medical expert comment on what future care is needed for the plaintiff, now you don't have to get a separate life care expert. And the same thing on the plaintiff's side. You don't necessarily have to get a life care expert. Maybe you can get it from the treating doctor. And this is true of any experts you may use in a case. But I see a lot of cases reported out there in big cases where they have 6, 7, or 8 experts. And, the more you put experts on, the more likely one of them is going to put his or her foot in the mouth. You want to keep your cases simple. So if you want to settle your cases early, my suggestion is I would spend the money. If it's a big case, I would spend the money on the experts and show what you're going to do, because the defense can only act on what's there, not on what's speculation. You can wait until the end, but it makes it harder for everybody to evaluate the case. And it's how do you settle a case if people can't evaluate it? Very difficult. Now, I want to talk about this. This, I think, is important. Fast tracking. I've done this many times on the defense end. It was sort of having been a plaintiff's attorney, I always felt that this should happen. There's no reason insurance carriers can't fast track a sort of a pre-discovery meeting to find out what the case is all about and then see if it can't be settled. And I do this with a stipulation. And the stipulation says that nothing that happens at this meeting, this fast-track meeting, will come into evidence. And when I first started out, I did it without a court reporter because I just thought it would work fine. But then I found I was scribbling the whole time to write down everything that the other side was saying. And so now we order court reporters. And again, the transcript can't be used for anything except settlement purposes. And basically, when I'm on the defense end, I sit down with the plaintiff and the plaintiff's attorney, and sometimes if it's a big case, with the insurance adjuster there too, because why not have the insurance adjuster see what the case is all about? That's the person who's going to be spearheading the charge to get the case settled. So it takes an hour or two, and it's almost like a deposition, but it's not formal. It's more conversational. You find out what happened, what the injuries are, what the damages are, and most importantly, what the people want going forward. Because a lot of times in negotiation, it's not just money. Are they looking for peace of mind? Are they want to put the kids through college? What is it in a big case? And I find it works best with big injuries, and it can work well with big injuries if there's only one defendant who's going to pay. It can also work well with big injuries where the liability is lousy, but there's one defendant who's going to pay, because the whole point is, do you want to litigate for 5 years over a case where it could be a defendant's verdict, or the case could get thrown out, and pay all the costs and the expense of all that litigation, or do you want to sit down and resolve it more quickly? And so we've often done these fast tracks, and then we follow them up with a mediation. And surprising number, very high number of them settle because the money's early on. We're realistic about what the cases are worth. My favorite example is the one I had with a guy who was a heavy truck driver who was getting something off a rack to put on his truck, and it was in a premises that was owned by his employer. So he couldn't sue his employer, and he got up on this rack and it collapsed. And he had a badly fractured wrist. He was out of work for 3 months. And he had permanent restrictions on what he could use his wrist for, although he did return to driving truck. And he didn't really want to sue but he was back in his child support because he'd been injured, and the Child Protective Services told him they were going to take away his driver's license if he didn't pay up, which, again, is another catch-22. How's he going to make the money without the driver's license? So that drove him to attorneys who contacted me, and I researched the law in the case, and it was really a no-liability case, although New York has this labor law, and the thing he was doing was somehow related to a labor law project 50 miles away. And the law, and it still is today, is that, it's not covered if it's a distance away. But there were facts on this one that made me think that, this guy, it was no fault of his own. And if, the case went on, I felt there was a significant chance that if the case went up on appeal, it could actually change the labor law. And it was going to be very expensive to defend. There was a lot of facts, and the guy had a bad injury, and it was going to go on up on appeal, I was almost sure, if it wasn't thrown out below. We sat down and settled the case, and plaintiff's attorneys got a nice fee. The guy got the money he wanted. Was it a huge case? No, but he wasn't looking for that. He was looking to move on with his life. And so there was enough proof and enough suspicion that the liability could change on appeal that I was able to convince the insurance carrier to settle the case. And everybody went home happy. And again, the whole thing lasted from the time the case started until it was settled, about 3 or 4 months. And I always felt good because everybody got something good. I really like win-win situations. And the trouble with the courtroom is that that's a win-lose place, and you never know what's going to happen. You want to try and give everybody something and let them go home. And in return for that, you eliminate the uncertainty and everybody gets some money. And that's one of the reasons I got into doing mediations, because that's what my whole inclination was. I never liked it when one side wins and the other side loses. I'd rather have everybody get something they need and live to fight another day. And obviously here's the, mediation or arbitration can help you close the case. Here I want to briefly talk about something we're pushing now more, which is if you can't settle the case for whatever reason at mediation, it looks like, okay, you just can't agree. Is there a way to try only the part of the case that needs to be tried and then sort of have an agreement, like a modified form of a high-low agreement that gives each side something once that part of the case is tried? And typically, I like to use it in situations where the injury is bad, but the liability is very tenuous. And what it does is it guarantees the plaintiff a low, and at the same time, it guarantees the defense that they don't get a runaway verdict going forward. And what I've done that I like is that you base the amount of the award on the percentage of culpability of the plaintiff. In New York, it's a comparative negligence state. So you get the highest award if you have no culpable conduct, and then if you got 50% culpable conduct, you get like the low, whatever that is. It's a good thing. So my recommendation is when you go to mediations, and if the case can't settle, sit back and take that second step. Well, is there a way that we can reduce the burden of trying the case? And specifically where we've used it, the trials are just on liability. They last a bifurcated trial. They last about 2 days on the liability, or 3 days, something like that. And your damages are already pre-calculated by the high-low settlement agreement. And it's based on the doctor's reports and the rest of it. Everybody's negotiated it, but you don't have to bring your experts in for trial. And the trial is much shorter, so you get to spend more time with your family on the night and the weekends. So I think we should be doing this more in our work, wherever we can find it. So in conclusion, get your information early, be aware of how things could change, and be realistic. And I think you'll have better results consistently that way, and we'll all have more time with our friends and family. Thank you. Kelly, I'm going to turn over to you. I don't know if we have any questions.
Excellent. Thanks, Bob. Yes, we do have some time left in the hour, and we've had great engagement from the audience. We'll go ahead and read out some of the questions that we've gotten and answer as many as we can. The first question that we have here is, in certain jurisdictions, many plaintiffs' attorneys use bad faith as a strategy to leverage a larger settlement. How do you work with this to resolve a claim?
That's interesting because I'm actually lucky being in New York. We're about, what should I say? We're extremely conservative on bad faith for whatever reason, so we don't have to deal with it as much as people in Florida and Texas and so forth. I think that you have to look at your particular state. I know that I hear a lot about Florida in particular, and that the attorneys down there are very good at using the laws to force settlements. We're a lot more frustrated here in New York. But the bad faith laws, I think, take care of themselves. In other words, most of them, if you apply them the right way in your jurisdiction as a plaintiff, you really can force settlements. And I can't advise you on what insurance carriers do in those jurisdictions because I'm not involved with those. But it's like anything else. You've got to have your counsel advise you as to the consequences, and just try and resolve the case the best way you can. I mean, sometimes people feel very frustrated that the law in their particular jurisdiction is not fair in any particular area, but you always got to deal with it the way that it is. And thank God we have the Internet and the organizations of plaintiffs' attorneys, defense attorneys, and everybody can talk about it. So I would say I would definitely look in the state where you are at what the people on your side of the fence are doing that way and research it in more detail. But unfortunately, I just don't have enough experience with that bad faith area in other states.
All right. Another question we have is it a good idea for plaintiffs to raise a prior demand at mediation?
Well, if they've, let's say they demanded $1 million, and the insurance carrier agrees to go to mediation, and then they show up and they say they want $2 million. I don't think that's a effective strategy unless it's part of some kind of plan that the plaintiff's attorney has. I mean, sometimes I think it's shock and awe when I've run into that, where they think they just want to upset everybody. They think they're ultimately going to get more money that way. But it pretty much guarantees the case isn't going to settle. I've never seen one settle where that happened. It pretty much guarantees bad feelings, not that they matter that much, but I'm always trying to understand the other side's needs. And if it's a big case, usually committees are involved in setting what they will or won't pay. And, of course, if they've already had their committee and now all of a sudden you've doubled your demand, is it going to make a difference to them or not? So you've got to decide what you want to do and why you want to do it. Everybody's got a different style. But I think if you've got, a case you can't lose, no warts on it, it's a big scary case, and you're doing that just to try to scare everybody, I guess that's a way to try to do it. But I think it makes it take a lot longer, and I can't say that you're going to end up getting any more money doing it that way. So it's a tactic that nobody really appreciates. It just adds confusion. But again, everybody has a style. There are a lot of different styles out there of negotiation and case resolution, and the people who do those kinds of things, I'd be curious to see why they do what they do. Often we never know for sure.
Okay, great. Someone else has asked here, how close apart do you need to be to go to mediation?
Well, that's an interesting question. I think you can always go to mediation, but I like the idea that there should be a dialogue between the plaintiff's attorney and the defense attorney beforehand. Hopefully they can talk to each other. And then the plaintiff's attorney is relying on the defense attorney to tell him information that's reliable. Not that he's going to say what the numbers are or anything, but he can say my side's interested in mediation and so forth. And a plaintiff doesn't want to go in and think they're going to go into mediation and they get some kind of ridiculous offer that's way below anything they anticipated. So I think you can avoid that by trying to be as candid as you can about what you want in terms of settlement and sending the signals with your demand as to where you want to go from both sides. And oftentimes on the defense side, I don't know what the insurance carrier or carriers are going to do, but I'll often say something like this. I'll say, look, I've written it up as a significant and serious case. I don't know what they're going to decide, but I wouldn't be calling you to try and put it into mediation if I thought it was a waste of time. But I've, of course, tried to gain credibility throughout the case by not wasting the plaintiff's attorney's time, not doing anything unnecessary, trying to be very consistent in my behavior, and so I get a level of trust out there. And I mean, that's another reason why I like being a mediator. As a mediator, I have to have the trust of both sides. Mediation is completely by consent, and you need to have somebody who understands how to keep confidences, not to tell one side something that the other side doesn't want them to know, but at the same time, try and get the case resolved. So my advice is go to the mediation if you can, but really try to feel out the other side in advance so neither side is disappointed.
Great. Okay, we have about 4 minutes left. We'll fit in one last question here. The question is, are you seeing any trends that are causing mediated resolutions to spike upward?
Yeah, I have seen more mediations, and I've heard people on the insurance carrier end say that the claims people aren't, this is just some people, it's not everybody, but it's just an interesting thought, that the claims people really don't want to take responsibility for settling cases themselves, and mediation becomes a tool for them to do less hard thinking or hard work about settlement negotiations. I don't know that I agree with that. I think that there's a lot of room for error in our business, and I think the mediators have a pretty good idea of how things should go, and I think you probably end up getting better results with a third party there. And again, the people I was hearing this from, the person I was hearing this from was high up, and again, he's looking at it from a perspective of the cost of a lot of mediations and so forth. But I think the greater cost is incurred before the mediation stage, and that's one of the reasons I'm pushing the early mediation. I think it is good to have an independent person give these opinions, and I guess that's maybe why the mediations have spiked a lot. It's just a very good process. And the thing I don't like is when people go to mediation and don't settle, so that's why I say try and do whatever you can before you get there to make sure the other side has what they need. And so you have what you need.
All right.
So,
well, on that
note,
you
very much,
thank you.
Folks.
Yes, thank you very much, Bob, for your insights today, as well as Law.com for their support. We'd like to, of course, thank everyone for joining us. And just as a reminder, all participants will be prompted to complete an optional evaluation form, which will prompt you to enter the CLE code. You will then receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. Also, please note you will receive an email notification when the archive webcast is available for reference. So thank you all again, and have a great afternoon.